Okay, Mr. Chairman, we're ready when you are.
All right, Pam, you want to go ahead and start off?
Yes, I will. Good evening, everyone. I am Pam Davis, and the Planning Director of the Town of Fuquay-Varina. I just wanted to make an announcement. Some of the adjacent property notifications that were sent out concerning rezonings, upcoming rezonings at tomorrow night's planning board meeting were mistakenly advertised as being Monday, January 12th. Anybody that has climbed onto this meeting interested in those rezonings, I ask you to please tune in tomorrow night at 6 p.m. for the planning board meeting. Thank you.
All right. At this time, we will call the meeting of the Board of Adjustments for Fuquay-Varina, North Carolina to order. We've got several things on the agenda tonight, but let's start out with the approval of the minutes from the December 14th, 2020 Board of Adjustment meeting. Has everyone had the opportunity to review the meetings from December, the minutes from December?
Yes.
Yes. Do anybody have any corrections or changes to the minutes?
Yes, Chairman, I have two.
Okay.
They are on page 7 of the minutes, which is page 10 of the package
Okay, page 7.
of the minutes.
Yep.
All right, the very first full paragraph at the top, which starts, Chair Mike Dorman asked.
Mm-hmm.
All right, the first two references to impervious surfaces are written as imperious surfaces.
Yep, I see that. Okay.
That's the only thing I noticed.
All right. Does anyone else have any additions or corrections to the minutes? If there is no additions or corrections to the minutes, I would entertain a motion to approve the minutes as corrected.
I make a motion that we approve the minutes as corrected.
All right, we have a motion to approve the minutes as corrected. Do I have a second?
I'll second.
We have a motion and a second. All in favor, raise your right hand. I think we can see each other. Okay. Motion, the minutes are approved as corrected. All right. The next thing we need to do is we need to elect a vice chair. Jeff has been gracious to do it for several years, and if Jeff would be willing to do it again, I would nominate Jeff to continue on in that role unless anybody else has a burning desire to take his place. Do we have any other person who would like to do that? And Jeff, would you be willing to serve another term as vice chair?
I'm willing to serve another term.
All right. Can I get a motion to appoint Jeff as a vice chair for the 2021 year?
I motion to appoint Jeff as the vice chair for 2021.
All right. Can I get a second, please?
Second.
All right. All in favor, raise your right hand. All right, Jeff, it looks like congratulations to you and thank you very much. You do a great job. I do appreciate that because, you know, a lot of times that's a job that is takes place on very short notice when I know I can't make it. The next thing we have to do is I would like to turn it over to Pam to introduce the new staff to the board.
Thank you so much. Ethan Mayfield has joined the town's planning department on January 4th as a program support specialist. In addition to her primary role in supporting the planning department, she'll be serving as clerk to the planning board and board of adjustment both. So we are excited to have her on board, and she's getting a little practice tonight taking the minutes.
Well, we look forward to working with you and can't wait to meet you in person.
Thank you. I look forward to meeting everyone as well. Thank you so much.
All right. Well, do we have anybody else that needs to be introduced?
That's it.
All right, at this time then, we're going to move right on into our training session tonight, which is going to be given by the town attorney, James Adcock. So James, I'll turn it over to you at this time.
All right. Thank you, Mr. Chairman, and I'd like to welcome all the new members and look forward to meeting you in person, and hopefully we'll be done with Zoom meetings maybe this year. That's my hope. But annually, we typically go through this training covering quasi-judicial hearings. The term quasi-judicial, that kind of the dictionary definition of that is noting, pertaining to, or exercising powers or functions that resemble those of a court or a judge. And participation on this board is a court-like proceeding, when we're considering cases. There are a lot of due process considerations that have to be made. It's not a political board or a legislative board like the town board would be, and it's not an advisory board like the planning board. The Board of Adjustment kind of exists on its own and has its own authority. So topics to be discussed tonight, and Scott, you can advance the slide one. I'll let you know every time we do a slide. I can't control it here. We'll talk about board structure. We'll talk about the three main activities of a Board of Adjustment, which are issuing variances, special exceptions, also known as special use permits, and dealing with appeals of the zoning administrator. And we're going to talk a little bit about due process, evidence, how we hold a hearing, our procedure, conflicts of interest, recusals, and ultimately making our decision the best we can. Okay, Scott. So the three roles of the Board of Adjustment are variances, special exceptions, or special use permits, and appeals of the zoning administrator. These things start out with a petitioner who's typically a property owner, especially the variance and special use permit realm. Most of the time, all three of these really, but they usually meet with planning staff. They fill out paperwork, a petition, a mail notice goes out, according to statute. And this notice is mailed to abutting property owners, the petitioner, and the site is posted. These hearings that we open up, they're subject to open meetings laws. Anyone can attend in the public. And these three items, variances, special use permits, and appeals, are the three considerations that the Board of Adjustment can make. And as I stated earlier, the Board of Adjustment is an independent board. It's created by the town board, but it's independent in its jurisdiction, which this slide demonstrates. A Board of Adjustment decision can only be appealed to Superior Court. So if someone's here and we make a decision that they don't agree with, they can appeal it directly to Superior Court. There's no review at the town board level. Now, the town board creates the Board of Adjustment. The town board could theoretically dissolve the Board of Adjustment, and it could act as the Board of Adjustment on its own. There's a statute, it's 160A 388, if you're interested, that outlines a lot of what we're talking about tonight. A lot of this material, when I started, was all case law, and in 2013, a lot of this was codified, and it's made life a whole lot easier and been better to guide boards, whereas a lot of the older materials that we use were just based on cases and trial by error. Okay, Scott. Scott, you can advance it. All right. Okay, the first thing we're going to talk about are variances. North Carolina courts, as I said before, these were codified in statute. They dealt with several findings that had to be made. These are dealing with practical difficulties, unnecessary hardships, the spirit of the ordinance is preserved, public safety and welfare is secured, and substantial justice done. These were kind of the old findings, and a lot of what towns adopted as part of their codes, they involved findings that revolved around these things. At one time we had multiple findings that we had to find. And then with the 2013 codification, Scott, you can go ahead and advance it. We've come up with 4 variance findings, and these are pretty much applied across the board. These are set forth in the statute. And these 4 findings that the applicant has to show the board. The first one is unnecessary hardship must result from the strict application of the ordinance. It's not necessary that no reasonable use can be made. It's just the hardship has to be an unnecessary hardship. The hardship results from conditions that are peculiar to the property, such as location, size, or topography, personal circumstance, and hardships that result from conditions that are common to the neighborhood or general public. They are not to be used as a basis. You know, if you've got a subdivision and there's all the lots are similar in size, you can't just come through and issue a variance for everyone because that's something common to that neighborhood, maybe a setback variance or something like that. But if you have one lot that's different than the others, maybe it's shaped different or it's irregular or there's topographical differences, there needs to be some distinction that makes it peculiar to the property. Okay, Scott? The hardship did not result from actions taken by the applicant or property owner. But the caveat to that is, if I buy a piece of property that has an issue that's existing, the fact that I bought the property, that doesn't count as a self-created hardship. If I have a piece of property and I subdivide it and I leave myself with some little remnant and I've created my own problem, you know, that's an issue. But if I buy a piece of property, I can't be precluded from seeking a variance, you know, under this hardship as a result of my own action. And then we got this catch-all feel-good number 4. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. And if you read through these and compare them to those old case law concepts that we talked about about 2 slides back, you can see how these were codified. And yeah, they form the basis of variances for pretty much every town in the state that has a board of adjustment and deals with these issues. So next slide, we'll talk about what is a legal variance versus an illegal variance. We got a couple of examples here. First one, allowing for the reduction in the required number of off-street parking spaces from 13 to 11. What's everybody think on that one? Is that a legal variance or an illegal variance?
It's an illegal variance.
Now, I think that one is a legal variance because you're varying a standard. If we're cheating here, there's only one of these that's an illegal variance. Which one's that? If anybody wants to guess out of these 4.
Number 3, maybe? No,
Close.
Number 2.
Number 2.
okay.
Yeah, you cannot have a variance that changes a use. Variances are dealing with, you know, going from one number to another and maybe altering a setback, altering a height standard or a parking standard, something that you're doing that. But those are all standards in the ordinance. They're not uses. But changing, if a daycare facility is not allowed in this zoning district, that will be a creature that for the town board to vote on and try to rezone the property. So we can't have use variances. So that's the moral to this whole slide here is there's no use variances. And most of the time, the board is never really going to have to deal with this because the staff does an excellent job of weeding these things out at the petition level. So they've already seen these. Most of the time, we try not to bring things before the board until they've been vetted and we've had a conversation with the petitioner. So that's variance. I'd say variances and special exceptions, special use permits are the 2 most common things you'll see. Most common is probably setbacks, where people wanting to build on the structures. They have an irregular shaped lot and they're reducing a buffer requirement or their setback requirement. Those are kind of your classic ones. I've seen a few where it was the height of a structure like a house. They wanted to get a variance on height. So those are your classic variances. All right, next slide.
So you're saying that we would never have to determine the legality of anything that came before us?
Well, if somebody tried to push that and they went against staff advice, that we may have a conversation or definitely ask the question, because I'm at all the meetings and, you know, we can make that determination. If the board determines that, board could refuse to hear the case.
Okay, I see.
Yeah. But we try to head those things off when they meet with staff and they usually are in concert with me if there's any kind of issue, early on before it's even advertised or
All right,
posted. Okay.
all right.
All right. The next one is special use permits or special exceptions. These are uses, and kind of start out with uses. The town has a use table in the LDO, the Land Development Ordinance. You can go online to Municode or on the town website and look at it, and it'll set out different zoning districts like downtown zoning districts, commercial, form-based. And there's a list of letters that'll either have a P for permitted or an S for special use permits, or it'll have a blank, it's not permitted in that zoning district. So any of those uses that have the little S on it, they require a special use permit. So if someone has that property and they want to use that property for one of those special uses, then they had to petition the Board of Adjustment, and there are standards that had to be met. And some examples of those in our code are, and a lot of times it's things that may not quite fit. They're things that need special attention or scrutiny, such as manufactured home subdivisions, airports, landing strips, things in industrial districts that may be more offensive, to adjoining property owners. And the Board of Adjustment acts kind of as a fail-safe for a stop against, someone just being able to have a permitted use. As you can tell, these things are all just higher intensity uses or ones that don't necessarily blend in with your traditional uses. So I'd point you to the use table. It may be good to look at that kind of as your homework and just kind of see what all we may be looking at. Okay, next slide. And like I say, different zoning districts, the list varies. Some of them have performance criteria that are special for the particular use. We just did a revamp of the manufactured home. There's a lot of requirements in there now that weren't in before. And also the Board of Adjustment can attach fair and reasonable conditions when approving a special exception. And most anything, the Board of Adjustment, both a variance and a special exception, the board does have the ability to attach fair and reasonable conditions. But these have to be zoning related conditions. The board can't, charge them, make them pay their neighbor $10,000 because they're damaging the property. It has to be something related to the property, zoning related. And the voting on the special exception is a simple majority vote. And I may have skipped back on variance. The vote is a 4/5 majority vote. I think I skipped over that earlier. We'll talk more about voting later. So variances are 4/5, special exceptions or special use permits, they're interchangeable terminology. They require a simple majority vote, and the appeal that we're going to get to later is also a simple majority vote as well. So for special exceptions, our standard special exception findings, next slide. The proposed use will not materially endanger the public health or safety if located where proposed and developed according to the plan is submitted. The proposed use meets all required conditions and specifications. What I was talking about just a second ago, if there are particular conditions and specs that go along with that use, it has to meet all of those. The proposed use will not substantially injure the value of adjoining property or the use as a public necessity. Sometimes we have held that things are public necessity because it may be a school is a public necessity, a fire station is a public necessity, a power substation. We had that case come up one time, and their argument was that was a public necessity. And you have another one here that's kind of similar to the fourth variance finding. You have this catch-all location and character. The proposed use, if developed according to the plan submitted, will be in harmony with the area and in general conformity with the plan of development of the town of Fuquay and its ordinance. And you basically, what this one means is if it meets all the standards of our ordinance, and a lot of this is based on engineer and staff testimony at these meetings, that it meets those requirements. And they've done a lot of that research before the meeting. The third, next slide. Third decision that the Board of Adjustment makes is an appeal, and it's referred to as an appeal from the zoning administrator. And the town of Fuquay, the zoning administrator, is the planning director, who's Pam Davison, who was on here with us. So someone has an issue on property, they disagree with the decision that the planning department has made through the planning director, then the planning director is going to issue a written finding typically of what their decision is. And that's our typical method of doing that. That way we start this 30-day calendar appeal period to the Board of Adjustment. And these are pretty rare. I mean, I've only seen a couple. We had a pretty intense one time a few years back on this. It was an appeal, but the board found for the planning director. So that was good for the planning director at the time. That was prior to Pam's tenure. But an appeal, if someone disagrees with the final written decision of the zoning administrator, they appeal it to the board. The Board of Adjustment has kind of three options. They can reverse the decision. They can affirm the decision, say the zoning administrator is right. Or they can modify the decision in conformity with the code. And anyone withstanding to contest the decision, which is typically the person who's there petitioning for the appeal, they can file an appeal with Superior Court, just like any of these other ones. If the board denies a special exception, special use permit, or they deny a variance, the appeal is to the Superior Court in Wake County. Okay. How are these cases handled? There's applications submitted to the town clerk. Whatever is in the record is sent to the Board of Adjustment members and the applicant. Person whose decision is being appealed must be at public hearing as a witness. And there's a possibility in the statute to have an expedited hearing if it's something really time critical that a hearing needs to be had to appeal a zoning administrator decision. So these are rare. Takeaway on that is you're acting as a court. You're going to review the ordinance that the planning director based the decision on and determine if that decision is right or wrong in part or in whole. And it's a majority vote on this as well. They're not particular findings. You're sitting as a court and you're interpreting the ordinance and making a decision, based on the ordinance and the facts that are on the record. And this is a majority vote. Okay. Okay, the statute requires and our LDO requires that the board have a set of procedures, rules of procedure, and these typically deal with officer elections, roles of officers such as the chairman, vice chairman, meeting dates, how special meetings can occur. The town board typically approves a meeting schedule every year for all the Board of Adjustment meetings and planning board meetings, town board meetings. The bylaws set forth attendance requirements, how abstentions are handled. If you miss too many meetings, you can get kicked out. Who can make motions, how votes are taken, how to deal with conflicts, recusals, and members who don't show up in meetings or show up late. So next slide. It's important you're dealing with rules of procedure that they don't conflict with the LDO or the statute. The statute has controls, then the LDO, and then the rules of procedure in that order. That's kind of the order of control. And if it's in the code, we typically try to keep it out of the rules of procedure. The rules of procedure just deals with procedural issues that are not addressed in the code or in the statute. And it's the chair's job and our job as a board and as council to make sure these rules are always followed. Okay. So this is some procedural background here. The application, as we mentioned a little bit earlier, has to be submitted on time before the case is processed. There has to be proper advertisement. There's mailing advertisement under the statute to abutting owners, to the petitioner, to the property owner, as well as, I think we typically put it on our website, and there's posting on the property as well. And when we come in here to have a hearing, we typically, at the beginning, the clerk swears all the witnesses in, which will be both planning staff and anyone who is going to testify at the meeting, because any evidence given, just like a court, is under oath as a sworn witness. And the purpose of the hearing is to gather evidence and facts to meet those findings that we discussed for whatever type of case we're dealing with. And the decisions have to be made on the findings, and the findings have to be based on facts. It can't just be financial impacts or personal opinion. As we mentioned, this is not a legislative board, it's a judicial board. So it's all about building a record, having your facts established, and meeting all the findings. Okay, next slide. Board of Adjustment must make findings that support their variances. It's a good idea to share findings of fact. And I think that the board does a good job, and Mike, the chairman, does a good job. When we get through hearing the evidence, we'll start with each finding, and the board will try to have a discussion and kind of put together the facts that their decision is based on. It's almost a polling of the board, and you try to build your motion based on facts. We're given a sheet, that has the finding, and it pretty much has the why question. And the why is really important on these. Whenever you're listening to these folks that are petitioners, I think you need to make good notes of the facts that are presented. And if there's any facts that you don't understand, put those in there, because the board needs to deal with those facts. They need to reconcile any facts that are not reconciled between the two. Let's say there's one side that's made one fact, that presented one fact, and the other side another. The board's going to have to try to reconcile those, to determine what evidence presented is competent evidence. So I think it's a good idea to talk about those things ahead of making the motion, and then make the motion include why the motion is being made, include those facts or findings as the board determines. And at the end of every hearing, these findings are put down in writing, and the facts that support them, and how contested facts were resolved. And they must be given to the petitioner in writing, which we handle, after the meeting as part of the order. The final decision must be sent to applicant or anyone who's requested a copy of it. And as we say again, this can only be appealed to Superior Court. Okay. Next slide. All right. How the hearing is conducted. The hearing is opened by the chair. Hearing procedures are explained. Now that we're in virtual world, there's a whole nother set of explanations too on how to handle these hearings on Zoom. And hopefully that'll be temporary, but it's what we've got now. Folks are sworn in by the clerk. People present their material evidence. Any evidence that's presented to the board, such as materials, exhibits, they all become the property of the board. And the board has those where they can review them and making their decision. And also, the chair should ask if all members can vote fairly. Any member has a conflict, has an opinion on the case, and they're not going to change their mind, or has had any unauthorized ex parte communication. We'll talk about all these when we talk about conflicts. So all persons are sworn in. Staff gives an overview of the case. Next slide. People that want to present evidence, they sign up and they use that so the clerk can have a record of that. The applicant presents their case. Anybody else who speaks, they're also sworn in that offer testimony as part of the due process, because this is a judicial hearing, quasi-judicial hearing. People who are sworn in can be cross-examined by the other parties. You can't just present your facts and not be subject to cross-examination. And the evidence has to be competent, material, and hearsay should not be relied on. Evidence is limited to that presented at the hearing. And then the chair closes the public hearing, and the board makes a decision. Now, the board can request clarification. Next slide. Or testimony given. That way, if there's some facts that are not reconciled, that the board can ask questions or call witnesses back up, to try to address those and reconcile those facts. And also, if the board decides to put some reasonable condition on a special use permit or a variance, then the applicant should be able to comment on those conditions, before they're approved, they're imposed. Something to point out here that's not in the slide. We talked about applicant presents his or her case. There is an unauthorized practice rule that the North Carolina State Bar has promulgated that says someone that gets up before a quasi-judicial board and gives and advocates for a client, which would be the classic case is, there's a company or a church or someone who's corporate. They're not an individual. Obviously, individuals can represent themselves, but folks representing entities, sometimes this can constitute unauthorized practice if it steps across the line into advocacy. And there's some state bar opinions on that. So the board could make a determination that's something we at least want to advise a petitioner if they're here without counsel and they're an entity, a company, church, something along that lines, that they really need to have an attorney, and it's advisable that they may be violative of that unauthorized practice prohibition, under the state bar opinion and the general statutes that prohibit the unauthorized practice of law. And we're really trying to push hard on this. I know in the past there's been some times that we've let it slide, but I think we've always advised that we're really pushing petitioners that are entities to make sure they have counsel. It makes the hearings go better, I think, and everybody does a better job when they're represented by counsel. Okay, next slide. So sorry for that aside. That was just one that's kind of come up here lately. The board deliberates after the hearing is conducted. It's where we talk about each of the findings. We try to determine what all the facts presented and what facts the board is going to adopt as part of their findings. They're going to consider substantial, competent, and material evidence presented at the hearing, not hearsay, not immaterial or irrelevant evidence. That's something the board would determine. The rules of evidence are not as strict as they would be if you were in a court proceeding for General Court of Justice or something in Wake County. But still, the rules of evidence still apply, kind of a lighter version, and the board should make sure that it bases its decision, say, on substantial, competent, and material evidence. So each finding of fact is reviewed, discussed, and a vote is taken on each one. It's really important that you do it on each, because this is part of the record. Each finding we independently vote on it and deal with it. Because if this were ever appealed to court, the court is going to analyze all those, and they may say that the board screwed up on one of them, but the other three, they did a good job on. So it's important to have those independently discussed and voted on. And you'll find in our procedure that we'll vote on each, and then at the end, we'll vote to deny or to approve the overall petition there at the end after meeting all the findings or not meeting them all. And as we said, final votes taken, they can be mutually agreeable conditions, can be placed on, they had to be land use related, and the applicant should be given time to comment on those. And that will be something if you gave, for example, if you gave a variance to encroach in a setback, maybe you would require them to have some screening or a buffer between them and their neighbor, so the neighbor doesn't have an adverse impact of a structure being closer to the property line. That would be something that would be reasonable and land use related, for example. Okay, next slide. Conflicts of interest. These are all situations where a board member's duty to act clashes with their inclination to advance his or her own interest or agenda. These can be financial conflicts, personal bias, or associations with those affected by a decision. In North Carolina, because this is quasi-judicial, you must recuse yourself from the hearing if you have a fixed opinion and that opinion is not subject to change. It's okay to have an opinion, but if it's somebody that you're not going to hear facts, no matter what facts were presented, you're not going to change your mind, then you would have a duty to recuse yourself. Undisclosed ex parte conversation, that is, let's say you're in the line at the grocery store and the petitioner comes up to you and says, "Hey, Mike Dorman, you're on Board of Adjustment. We got this case coming up next week. Make sure you vote for me. And I want to tell you why." And I start reciting these things and you engage me. It's fine if somebody comes up and says that, but you got to just tell them, look, I can't discuss this. You know, it's not permitted. It's ex parte conversation. It's okay as long as you cut them off. But if you engage them in that conversation, then that's problematic. So it's a good idea if somebody did come up and say something like that, then maybe you make the board aware of it. That way any conflict is, you know, is known. That way nothing could be said later. Or if you have a close familial business or associational relationship with the applicant, or you have a financial interest in the outcome. Okay, those are all conflicts of interest. And we could do a whole class on conflicts of interest and ethics, but that's the Reader's Digest version of what we've got here tonight. Okay, next slide. There you go. Competent evidence. We do not allow lay witness testimony on these three factors. And this was a fairly recent codification because you see this a lot. The use of property would affect my property values. People like to get up and say, if you allow this to happen, my property value is going to drop 50%. But if I get up and tell you what my property value is, I don't have any professional expertise. I will be a lay witness on that. I don't think the board can rely on that testimony. You know, if you want to discuss value, then it may be a good idea to have an appraiser as a witness who's a professional. Let's say an increase in vehicular traffic that would pose a danger to public safety. If you approve this, my kids are going to get run over. It's going to be dangerous. I'm not going to ever go outside of my house again. Yes, you would need a traffic engineer, maybe some type of engineer, you know, to testify on the increase in vehicular traffic. In other matters which expert testimony would generally be relied upon. And I know the chairman always asks before a witness presents, you know, for them to state their name and their professional qualifications, because it's important to know if they are an expert. And a court usually goes through that analysis. If you're bringing an expert witness, you know, they go through and they examine their qualifications and determine if they're going to be admitted as an expert witness. So the Board of Adjustment kind of does that as well. And we've had all kinds of folks. Your classic ones are engineers. You see that a lot with these cases. Folks who are civil engineers, landscape architects. See appraisers come up. We've had experts on electromagnetic fields. We've had experts on power distribution systems. Those are more of the interesting ones. But I'd say appraisers, civil engineers, landscape architects, you see those a lot on these cases. Okay, next slide. Admissible evidence, and this is kind of an examination of hearsay and competent evidence. Petition, somebody brings a petition and says, I have all 100 people, all of my neighbors have signed this petition, and this is going to be an idea. I mean, be a bad idea. That is not competent evidence. The next one, I saw it with my own eyes. You know, that's eyewitness testimony. That's classic admissible eyewitness testimony. That's fine. That's not hearsay. My mom, who couldn't be here, has lived there, and she says she's never remembered a store being on the property, and the applicant is lying. That would be hearsay because you're talking about what someone who is not at the hearing, not subject to cross-examination, says. The next one, I just moved here from New York, and we would never have allowed it there. You people are nuts. That's an interesting comment, but it's not a material fact, and you couldn't base a decision off of opinion, which basically is what that is. And this last one, you know, I live next door, and if you allow it, I'll never be able to sell my house. That gets into the competency issue that we discussed about property valuation. Just because somebody says that, you can feel for them, but in making your decision, you've got to base it on competent evidence and not just a more of a emotional type reaction, you know, based on adjoining property owners. Now, of course, you can use common sense. I mean, you don't have to have an expert tell you everything. I mean, there are certain things that are common sense. And I'm not asking you to remove those, and I don't think any court would. And we're trying to do a good job, take the best effort we can, and make a decision and kind of go from there. Okay, next. Cross-examination. We've mentioned this a couple of times. Cross-examination is important. It's fundamental to quasi-judicial proceedings. It preserves due process. there's constitutional concerns. If someone is presenting testimony, you need to be able to question them or ask them things to try to rebut or to impeach them possibly. And that applies both ways. If you're the petitioner, you have your witnesses. Person who's in opposition, who has standing, they can cross-examine those witnesses. They can put on their own witnesses, which the petitioner in turn can cross-examine as well. And this can occur at any time, during the public hearing section of the meeting. Once it's closed, everyone is done and had their opportunity. The Board of Adjustment makes its decision. Now, the Board of Adjustment, as we said earlier, they can call up a witness for a clarification. They can discuss with the petitioner the possibility of a condition they may put on one of these variances or special use permits. And the Board of Adjustment has the authority to subpoena witnesses independently as well by statute. Don't see that very often, but we had one case that we thought we were going to have to do that. It ended up working out, but the Board of Adjustment does have that ability. So making the decision. Next slide. What are the facts? We'll harp on this. What are the facts, and how do these facts relate to each of the findings? That's the discussion the board needs to have when it goes into deliberation. That's what the important thing is for each member to look at and try to take notes on during the hearing, or what facts are being presented for each finding. And it's the petitioner's role to give you those. And the burden of proof is on the petitioner. And if they don't give you enough facts, then the board needs to be asking questions to try to ferret out those facts. And if you've got enough factual evidence, you always want to look at these things and, does it make sense? Is it being reasonable? Is it using your common sense? A lot of these things are very common sense in nature, just like you would if you were a judge. A lot of those decisions are common sense, and you apply the law in a way that makes sense. Next slide. Okay, we've talked about these special voting requirements. Variances are 4/5. Appeals and special use permits are majority. And what's interesting is this 4/5 vote is unique to the Board of Adjustment. It's not required for recommendations made by the Planning Board or the Board of Commissioners. And we used to have something called a protest petition that required a supermajority, and that has been repealed. So that's not even applicable anymore. I just leave it in here just for the historical context. And the decision, the denominator of your vote is based on the number of folks on the board, the constituted board. And this denominator can be adjusted for vacancies and disqualifications, which a disqualification is a recusal. Now, absences don't count. So if you're absent, that does not reduce the denominator. And alternates can fill in if there's a vacancy or if there's a recusal, and they function the same as a regular member in that instance. Okay, we'll flip over and we've got some math problems. I will try to work my way through this. It's not my strong suit. So variances. We've got a 7-member board. We have 7 regular members and 1 alternate. We need 4/5. And according to my Fuquay math, 4/5 is 80%. So if we have a 7-member board, let's say this first question. 7 members are present and able to vote, and you've got an alternate sitting out in the audience. You got a 7-member board. So 80%, you're going to have 6 members to get to 80%, because you can't have a half a person or a fraction of a person. So you got to go to the next whole number. So that's 6 out of 7. Okay, this next one, say we have 6 regular members that are there and they're ready to vote and able to vote. 1 regular member is absent and you have 1 alternate. So that alternate steps in and they function as one of the 7 constituted board members. You've got 6 regulars, the 1 alternate fills in for the absent member. The same number is required there. You've got 6 out of 7 to get your 4/5. Okay, on this next one, you've got 6 regulars. And then you've got 1 regular member who's recused from voting. So this is a little bit different. Our denominator gets adjusted in this instance. We have a 6-member board now. because we have no alternates and the one is recused. So they're disqualified. So now, in order to have 4/5, we've got to have 5 out of 6 members. And this last one, if we have 5 members that are appointed and present, 6 and 7 haven't been filled by the board, so they're vacancies, and you have 1 alternate present, then we've got 6 members as our denominator. So there again, to have 4/5, you would have to have 5 of the 6 to get your 80%. So that's the variance. Those are the harder ones to figure out because you got to figure 80%. Majority is a little bit easier for special use permits and for appeals, and that's the next set we'll look at. Scott. Okay, for this one, we're just calling it an appeal. It could also be a special use permit. Let's say we have 7 regular members present, ready to vote, and able. 1 alternate sitting out in the audience. Got to have a majority. The majority of 7 would be 4. So the answer to the first one's 4. Same on the next. You've got 6 regulars. 1 of your regulars is absent, and then 1 alternate. So the alternate steps in for the 7th seat. You got 6 regulars. 1 alternate serves as number 7. So there's 4 again on that one. You have 6 regular members able to vote, and 1 of them is recused, and no alternates present. Then we've got 6 members. So we have a majority of 6, which is 4. Because 3 is 50%. You got to have 51%, so you're still 4. Used to we had 6 members on the board, and this math was more fun. Now it seems like everything requires 4, and I like that way better. And this last one, 5 members appointed and present, 6th and 7th aren't filled, you have an alternate. So there again, you've got a 6-member board, so a majority is 4. Okay, I think we got those covered. Okay, some important things to do when you're serving on the board from a practical standpoint. Listen to what folks are talking about. Is it reasonable? Does it make sense? Ask a lot of questions. Just because somebody says it, don't necessarily believe it. Some folks are a little bit quieter than others as petitioners. Now, if you get a bunch of lawyers in there, they're going to get in there and charge by the hour, so they'll give you plenty of information. But I've had some of these, especially lay folks, will come in, and the most hilarious one that I ever had, and this was on even before my time. I sat in as town attorney when the former town attorney couldn't do it. And this guy, he wanted a variance for height of his house. And I can see him right now. And every one of the findings, he said, well, I'm just ready to go to work. That's why I'm ready to go to work. And it was humorous, and they passed it. And I don't know if any of that was copied or anything, but Mr. Wade was ready to go to work, and he got his tall house, and it sits over on Wilburn Road now. So it's a really nice place. So he got his height variance, and I was thinking, yeah, you really need to try to pull it out of them. And if they don't go through their findings, Mike's done a good job as chairman. If they don't do it, then he punishes them by, making them read through their entire petition and go through those. So it's important to get those on the record. And if you don't have what you need, don't be scared to, you could continue the hearing, or you could table consideration if you need to get additional information. If it's going to look bad and the petitioner is not going to get what they want, if you don't have additional witnesses, maybe you need to let them know they need to come up with some, and we'll continue this to another day if you want to have a positive outcome. Haven't seen that happen here. I've had some county boards of adjustment that I've worked on that has happened. I've had some that have been continued. I've had some that were continued because they lasted so long. They lasted to midnight, and they just got tired of sitting there, so they continued them. But, the board does have that ability. And as always, a consideration about continuing the case. Okay, next slide. So, takeaways, give it your best shot. This is not exact. It's not a science. You're going to make findings based on facts, make decisions based on findings. Make sure you build a record. Those questions and all that stuff you talk about, it's all recorded. We record all of our meetings now. So all of that goes in the record. And one of your findings is found in the negative, keep on voting on the other ones. You want to make sure you vote on each individual finding. And I think that has me covered for kind of the 30,000-foot view of Board of Adjustments. If you got any questions, you can always call me up or call staff, and we'll be glad to talk about it and address it. But that's what I've got for tonight, and we'll let you out before 8 o'clock.
Thank you, James. Does any of the members of the board have any questions for James about the material he covered? Anybody need any clarification on anything? All right, James, thank you. You did a great job. I greatly appreciate that.
Mr. Chair, can I add a
Pam, do we have?
clarification?
Sure.
I just wanted to check. It was brought to my attention that our alternate Cassandra Flowers did sign into this meeting. So I wanted to welcome her. She was recently appointed. And I also just want to get clarification to see if she was available during the approval of the minutes and the vice chair. Cassandra, are you there?
Hi, I'm here. Can you hear me?
We can.
Hi, everyone. Yes, I was here. I've been here since the beginning. Yeah.
Perfect. Thank you so much.
Thank you.
Thank you for being here.
Thank you.
So Pam, do we have any applications for our February meeting?
We do not. There will not be a February Board of Adjustment meeting.
All right, everybody heard that. We're not going to have a February Board of Adjustment meeting. Do we have any old business that we need to take care of? Does anyone have any new business that we need to address? If we have no new business or old business that we need to discuss, I will entertain a motion to adjourn.
I make a motion, we adjourn.
Have a second?
Second.
All right, I have a motion to adjourn and a second. All in favor, raise your right hand. All right, this motion is adjourned, and I will see you in March if we have a March meeting. Other than that, thank you all very much. And if you need a copy of this presentation so that you can use it for reference or study guide, just reach out to Pam and she'll be able to provide it for you. Thank you all for being here tonight.